Doc Talk. Yeah, we keeping it smooth. Your favorite paralegal got the legal groove. From the stars in the courtroom to your cousin's case, we breaking it all down. No rush, just pace. Good morning, fam. Good morning. So we have new docket activity in the Karmelo Anthony case, and the court just received the partial reporter's records from the trial. And the timing of when these showed up tells its own story. Let me walk you through what's actually here, and just as important, what's still missing. I'm Cassandra, aka your favorite paralegal, and this is Legal Doc Talk. So, what you see on the screen, let me actually, I'm going to share another screen so you guys can actually see the entry, so y'all know that I am not just making it up. This is true, because you got a lot of people out there that say so. As you can see, there are several entries that says correspondent received by court. So this is the docket that is updated by the district clerk's office. So the court handed correspondence to the district clerk to file, and that is what we see on the docket. Okay, so I hope everybody is on the same page. So on July 13th, yesterday, 5 entries hit the docket. They all were logged on the same day. Now, one is an email correspondence between the court and the parties, and then the other four are labeled reporter's partial record covering the jury trial on June 1st, the voir dire examination on June 3rd, the jury trial on June 3rd, and the jury trial on June 8th. So, what we have now is partial coverage of 4 separate days, both jury selection and the actual trial testimony, not a complete transcript. Partial records filed piecemeal. All right. So here's what's making this very interesting. So go back to the motion for a new trial, which was filed on June 7th. In that filing, the defense said counsel contacted the official court reporter directly and was told nothing had been transcribed at all. Zero. These partial records are dated July 13th. That's 6 days after that motion went public. Now, I want to be fair about how to read that, because there's more than one explanation. The most likely, most mundane one: court reporters in high profile cases often work on a partial or daily transcripts in real time, and it's entirely possible production was already underway and it simply wasn't finished when the council called in late June. Nothing transcribed yet as of that phone call doesn't necessarily mean nothing was ever going to show up. Y'all got that part? Now, the less charitable read, and that one that's obvious, more interesting from a content standpoint, is that the public filing and the attention it drew, it was actually that's what actually got things moving. Okay. Now I can't prove that from the docket entry alone, but the 6 day gap between we were told nothing exists and the partial records start arriving is not nothing. Y'all get what I'm going? So maybe the pressure got some fire up under the court reporters, but who knows? But we need to talk about what's actually missing. And this is the part I think matters more than just the timing in question, honestly. Look at which days are not in this batch: June 4th, June 5th, June 6th, June 7th, and June 9th. Those aren't random gaps. Those are exactly the days at the center of the courtroom access affidavits we covered. The days multiple declarants said that the overflow room was eliminated. The days people said they were excluded entirely. The day family members describe being capped at 8 seats. So, what we have right now is a partial record of the less contested days, jury selection, and a couple of early trial days, while the days actually driving the Sixth Amendment claim are still not in the file, at least not the ones of this batch. So, that's the batch to actually watch out for next. If records for June 4th through 7th and June 9th come in, that's when we'll actually be able to compare the affidavit accounts against a contemporaneous record instead of relying on just the sworn statements alone. So, quick reminder of why this actually matters legally and not just narratively. Affidavits are sworn. And y'all, we've gone through this before. They are sworn and they're taken seriously, but they're still individual people recollections filed by one side, and the other side has not cross examined yet or even replied to the motion. A reporter's record is different. It's the court's own contemporaneous account of what happened in real time made by a neutral officer of the court. If the records for those missing days ever surfaces and it corroborates what these 8 declarants independently describe, the seat caps, the line management, the eliminated overflow room, that moves this from the defense says this happened to the court's own record confirms this happened. And that's a meaningful, stronger position heading into any evidentiary hearing. Now, to be clear, I'm reading a docket entry here, not the actual content of these partial records. I don't know yet what they say, only that they exist and which days they covered. And there could be a completely ordinary administrative explanation for the sequencing that has nothing to do with the motion at all. I'm flagging the pattern, not the asserting cause and effect. So I'll keep watching the docket for the rest of June records, especially, the June 4th through the 7th and the 9th. And that's the batch that actually tests the affidavits, the one from June 4th through the 9th. So follow so you don't miss it. You better make sure that you're subscribed to Legal Doc Talk so that way if I put out any new videos or go live, you are in the building. I'm Cassandra, aka your favorite paralegal, and this has been Legal Doc Talk. Bye.